Good afternoon, everyone, and thanks for joining this session on right to work checks for HR and on some recent changes that have come in since the 1st of July. So for those of you who don't know, I'm Elaine McIlroy. I'm one of the partners in Brodie's Employment and Immigration team, and with me today is Erin McLafferty, who is a solicitor in the team as well. And the session is going to be in two parts. And in terms of what we're going to cover, right to work checks, of course, are important for every employer. They apply to every business, regardless of whether or not they sponsor migrant workers. And today we're going to focus on some recent changes to them, which came into place on the 1st of July, following the end of the grace period, which Erin will explain when she comes on to that. We're going to cover those changes, also whether the sort of thorny issue of whether employers should carry out retrospective checks in relation to European nationals and what issues you need to think about if you're considering that. We'll then turn to sort of three different, what I've called their special cases, and that's in relation to European nationals who've perhaps applied to the scheme but they haven't had their outcome yet, and what employers are supposed to do about those individuals. Also, where you've got an employee, an existing person in the workforce who just didn't apply by the deadline. And then the third scenario is for job applicants, so somebody brand new coming to apply for a job who didn't apply to the EU settlement scheme in time, so those late applicants, because they are being treated a bit differently than the norm, and we'll come on to explain that. And then finally, we'll finish with some practical tips and a look into what the future will hold, and hopefully some time for questions and answers. So I'll hand over to Erin at this point, who's going to start off the session.
Great, thanks Elaine. Yes, so to begin, we're just going to have a quick look at right to work checks and the interaction with the EU settlement scheme. As most of you will know, right to work checks provide employers with what's called a statutory excuse if it turns out that they have employed an illegal worker. A statutory excuse is essentially a defence to any civil penalty or fine that an employer may get as a result of employing an illegal worker. Generally, these checks will be carried out before employment commences, and in some cases where you have an employee with time-limited right to work in the UK, you may also have to do a repeat check at a later date. Before COVID, I'm sure most of you were familiar with doing a manual hard copy check, and that involved getting a hard copy document, whether it be a passport or a visa, doing your regular normal checks and then taking a photocopy of the document. However, there has been a general move towards online checks rather than these hard copy manual checks. In part, that is due to COVID and the fact that everyone has been working remotely for the last 18 months, but also because of the introduction of the EU settlement scheme. This is one of the first schemes that was introduced in an almost exclusively digitised format. And that means that those that apply to the scheme do not receive a hard copy document or biometric residence permit or visa. Their status is exclusively held online, and they evidence that right to work through an online portal. EU, EEA and Swiss citizens were given 6 months after the end of the Brexit transition period to apply through this EU settlement scheme. This was known as a grace period, and it came to an end on the 30th of June 2021. And that was also the date on which the EU settlement scheme closed to certain applicants. But it is worth bearing in mind that a flexible approach has been indicated from the Home Office in relation to late applications for those who have had reasonable grounds for missing the deadline. The EU settlement scheme also remains open for many applicants, including those who are switching their status from pre-settled to settled status, and also certain qualifying family members who are coming to the UK to join their families in the UK who are actually eligible to apply into 2022. So it's worth being aware from an employer's perspective that while the EU settlement scheme and the grace period have come to an end and closed, there may still be cases and circumstances where you will come across an individual who has made a late application or who is still eligible to make an application to the EU settlement scheme, and that may impact their ability to work for you, and we'll chat a bit about that later on in the session today. On the next slide, I've indicated the right to work offences and the cost of getting it wrong. So if you don't do a right to work check in line with the guidance, there's two kind of offences that apply. There is the criminal offence and the civil offence. The criminal offence is that of knowingly employing an illegal worker, so that's knowing that someone doesn't have the right to work in the UK and employing them anyway. And it also includes employers who have had reasonable cause to know that someone was not eligible to work for them in the United Kingdom. There are tough sanctions that go along with that. So individuals can face up to 5 years of imprisonment or an unlimited fine, but it is usually reserved for the most serious cases of a non-compliance with right to work checks. And we don't see it in practice that often, given that it's reserved for very serious offences. What we do see much more often is a civil offence, and that's of negligently employing an illegal worker. If you're found to be employing an illegal worker, you may be subject to a fine of up to £20,000 per person. However, as I touched on previously, if you do a right to work check in line with the guidance, you may have a defence to any of those fines, and that's called a statutory excuse. But there's also reputational and operational risks in relation to the civil offence. So there is also a public list of all employers who have been found to have an illegal worker, and that's in the public domain. And there's also the operational risk of, if you have a sponsor licence, which some of you may do on the call today, having a civil penalty or receiving one of those civil penalty fines that I mentioned may also impact your sponsor licence. In some cases, it may be downgraded, or in serious cases, it could be revoked. And if you're reliant on that sponsor licence from an operational point of view, that could be a disaster for your business. So very important to make sure that you're complying with right to work obligations and that you know the risks of getting it wrong. On the next slide, we're now going to look at the 1st of July changes and what's happened as a result of them. So the Home Office guidance was changed, or came into play with new changes from the 1st of July to coincide with the end of the grace period and the closure of the EU settlement scheme to some applications. To further complicate things, there was also another announcement of changes on the 6th of August, and we will chat about them today, but it's worth bearing in mind that the current Home Office guidance does not reflect those 6th of August changes just yet, but we will cover them on today's session. In terms of the changes that took effect on the 1st of July, the key ones were that EEA and Swiss passports and ID documents were removed from the list of acceptable right to work documents. Irish passports and frontier worker permits were added on to that list. EU settlement scheme status wasn't added on because it was already there, but it does remain there in light of these changes. And the Home Office also gave some confirmation on their position and some guidance on retrospective checks, which we'll come on to chat about shortly. And it also included some interim measures that are in place until the 31st of December this year, which we'll also come on to chat about shortly. So in relation to doing a right to work check, then what has changed from the 1st of July? If you're going through a recruitment process and you have a recruit or a candidate who is from the EEA or Switzerland and you want to offer them the job, you will have to do a right to work check on them as you would for anyone else. But it is important to know that you can no longer accept an EEA or Swiss passport or ID card for those individuals. If you do accept such a document, you will not establish a statutory excuse or a defence to any civil penalty if that individual turns out to be an illegal worker. Instead, if the individual has leave under the EU settlement scheme, they should provide you with what's called a share code so that you can do an online check. And I'll talk you through what that looks like on the next slide. But if the individual does not have status under the EU settlement scheme, they will need a visa or other visa permission to work for you in the UK. So that might be a skilled worker visa or a family visa, depending if they have British family members or something similar. So in terms of doing a right to work check then from the 1st of July, to do this for someone that has status under the EU settlement scheme, you will go on to the View a Job Applicant's Right to Work Details page on the gov.uk website, and it should look similar to what's on the screen there. To go and do the check, you should click on Start Now, and it will ask for the date of birth of the job applicant and also their share code. In terms of getting the share code, the individual will give that to you direct, and how they do that is through their own personal portal, which shows their status digitally. So if they have leave under the EU settlement scheme, they'll have access to a portal to evidence that. The next slide will show you what you should receive. So if they go onto their portal and they request a share code is sent to you, you should receive something similar to what's on the screen there. It will give you that share code, which is a magic number that you need to do the check. You should input that and the date of birth into the screen I showed you before, and then hopefully it should throw up something that looks like the next slide, which will confirm that the individual has the right to work in the UK. If there's a time limit to that, it will confirm the date to which their right to work expires, so that you can diarise for a follow-up check as necessary, and it will then confirm any conditions or anything you should be aware of in terms of that employment. You might be able to see at the bottom there's a link to view a PDF of the page, and that allows you to export that document into a PDF document so that you can then go ahead and save it in the appropriate HR file as required. I would flag that this is not a new process. The online right to work service has been in place for a couple of years now, but you may find yourself using it more often now that the EU settlement scheme will be used by a lot of employees to evidence their right to work in the UK. So it's worth being aware of and being familiar with. I'm now going to pass over to Elaine, and she's going to chat a bit further about retrospective checks and things you should be aware of.
Thanks, Erin. So yes, I'm going to turn now to the question of whether employers should do retrospective checks, given the fact that the EU settlement scheme has now closed, and there was a window in place of about 6 months when the Brexit transition period had ended. People could still be coming into the UK just using their European passports, but they may not be eligible for the EU settlement scheme, or to deal with the fact that certain individuals may simply have not applied through the scheme. And the Home Office guidance that was published with effect from the 1st of July makes it clear that employers aren't expected to do retrospective checks. They're not necessary and they're not mandated. It does, however, acknowledge that some employers might elect to do retrospective checks in some cases. So it acknowledges that that is a possibility, but I guess there are certain pros and cons to think about if you're considering doing them. And the Home Office guidance makes it clear that if you do elect to do additional checks which are not required, you must do so in a non-discriminatory basis. And the most likely form of discrimination claim that could be relevant in this case would be a race discrimination claim, and there is guidance available on the .gov website about how to carry out right to work checks on a non-discriminatory basis. And the concern with carrying out retrospective checks targeted on, for example, just European nationals and not others, is that you could then be faced with certain race discrimination risks in a context where the Home Office has not said that you had to do those retrospective checks. Their position is that if you did the right check that was required and that was in place at the time when the person was recruited, then you don't need to go further than that. So for example, if the European passport was accepted and an acceptable form of right to work at the time that the person started work, you don't need to go beyond that. If you are thinking about doing additional checks because you want to flush out whether you have any individuals working for you who don't in fact have permission to work through the EU settlement scheme, then an audit of your right to work processes across the board for every employee is likely to be okay, because you're not targeting that towards certain individuals of certain nationalities. In addition, some employers might choose to do it on those employees who are involved in, for example, international travel for business purposes, because they might want to then make sure that those individuals aren't going to have issues coming back into the UK. And again, that's likely to be okay. But if you do target those retrospective checks on certain nationalities, that's where the race discrimination risk may come into it. In terms of the pros of doing retrospective checks, which go above and beyond what the Home Office requires, some employers might want to do it in order to flush out problems at an early stage. And what I'll come on to talk about later is the fact that the Home Office has put in place interim measures that are only in place until the 31st of December this year. So they're only in place for a period of a few months. And what those measures do is allow the employer to continue to employ somebody who has either not applied to the scheme or they've applied outside of the deadline, provided that you as an employer take certain steps, and that process is only in place until the 31st of December. So if you were thinking about flushing out problems at an early stage, there is, I guess, a sort of benefit to doing that now, in that interim process is in place and will avoid disruption in having to terminate the employment of the person, provided that you follow this process. So we'll come on to look at what that involves in the next slide or so. So the first special case that I'm going to look at, this is for employees and job applicants who did apply to the EU settlement scheme, but they haven't yet received an outcome, and that's not hugely unusual scenario. There were something like 6 million applications to the scheme by the 30th of June, and there were lots and lots of applicants who hadn't yet received an outcome. Sometimes applications were taking weeks and months to be considered. So there are a number of people out there who've just not received the outcome yet. And for those who did apply in time, then the employer can continue to employ them pending the outcome of that application. The individual is likely to receive a certificate of application confirming that they've applied to the scheme, or an email confirming receipt of their application, and they're able to then provide that evidence to the employer. If the certificate of application was issued digitally, then the employer can use that to carry out an online right to work check along the lines of the process that Erin's explained. For paper certificates of application, or if the employee's got an email confirming that their application was received, then the employer can carry out a check using the employer checking service in order to verify that the person has an outstanding application and that they can continue to work. And that positive verification notice usually gives the employer a statutory excuse for a period of 6 months. During that 6-month period, the individual might get the outcome of their application, hopefully. In the rare cases where it takes more than 6 months, if you needed to, you could carry out a repeat check using that employer checking service. If the employee tells you they've still not received the outcome, then you could carry on and do a further one of those checks, and that will provide you with a statutory excuse in the event that it transpired that the individual didn't have permission to work. So that's the first special case, and that's along the lines that you would normally expect for any other type of visa application when somebody applies in time. We'll just now move on to look at the second special case. So this is for individuals who are existing employees in your workforce. So we'll come on to talk about job applicants, but for now let's look at existing employees, and either those who applied but missed the deadline of the 30th of June and they've applied late, or some individuals out there who just haven't applied at all. And that might come to the employer's notice in a number of ways, either if you are carrying out additional checks, or if, for example, somebody tells a colleague and they tell their manager and it gets reported to HR that somebody hasn't applied at all through the EU settlement scheme who you've got working for you, then this scenario might come to light. And as Erin mentioned at the beginning, there are these situations in which late applications are being accepted to the EU settlement scheme if somebody's got reasonable grounds for having missed the deadline, for example, due to illness or on some other basis. Then the Home Office has said that it's taking a fairly flexible approach. It's for the employer, this scenario, if we just move on to the next slide. The Home Office's guidance, which is in place until the 31st of December 2021, suggests that the employer signposts the individual to go off and make an application if they haven't done so to the EU settlement scheme. You would do that by referring them to the Home Office's official website, which has got information about how to apply. They should be invited to apply within 28 days if they haven't done so already. And it's important for the employer not to actually give immigration advice to an individual unless you're a regulated person. You're not entitled to do that, but signposting to the Home Office's website is fine. The individual would then provide the employer with confirmation that they've gone off and applied, so they would have either that certificate of application or an email confirming receipt of their application through the scheme. If they choose not to go and apply within that 28-day window, then the employer should take advice and consider dismissal if the individual's just not going to go off and apply late. But if they have applied, albeit that they've missed that deadline, the employer has the ability to request a check through that employer checking service, which should give the employer a positive verification notice. So provided the individual has indeed made their application, that would then give the employer a statutory excuse for a period of 6 months usually, which is that window of time which enables the individual to get an outcome from their application. And the thing that's a bit different about this interim process, which is specifically for the settlement scheme, is that normally someone had missed a deadline for applying for a visa, etc., then they wouldn't be able to work in the meantime. This gives employers the opportunity to continue to employ someone despite the fact that they didn't make that application in time. So it's an extra sort of special concession for EU settlement scheme applicants. If we just move on to the third special case then, so this is job applicants, so not people in your existing workforce, but somebody coming to apply for a job with you, and again, they haven't applied to the EU settlement scheme at all, or they haven't applied in time by that 30th of June deadline, which applies to most people. And new guidance was released by the Home Office on this point on the 6th of August. It was a sort of change of position from that which had previously been set out. So the expectation was that a job applicant who hadn't applied in time would simply not be able to start work until they get their permission sorted. But this new guidance basically introduced, again, new sort of concessions, which are described as exceptional temporary protections for applicants to the EU settlement scheme, and it basically allows those who have applied late to take up employment, even if it's a new job, whilst they await the outcome of their application. Again, the individual in this scenario should have evidence that they've applied to the scheme, and that would normally be a certificate of application. The employer can carry out a check through the employer checking service on that job applicant, and provided that that comes back with a positive verification notice, then the individual will be able to work, start work for a new employer pending the outcome of that application decision, which they will get in due course. And the Home Office has said that they will publish more detailed guidance on this, so we're expecting the sort of main guidance to be updated to reflect this change in position. If we just move on then to the next slide. So one question we're sometimes asked is, what about the risk? Erin had mentioned at the outset, that sort of criminal offence of knowingly employing an illegal worker. The Home Office's comprehensive guidance does deal with this issue in relation to those interim measures that are in place until the 31st of December. And they say, provided that employers follow the guidance that the Home Office has put out there and employ somebody in good faith and does what is expected of them, then it's they say that the criminal offence is for the most serious cases and isn't intended for that category of employer. So they're giving comfort there that criminal proceedings are not going to be taken if an employer follows the process that was set out. If we just move on to the next slide, then I just wanted to mention on a related but slightly different topic, those temporary COVID right to work checks which Erin mentioned. So as of March 2020, at the start of the pandemic, they introduced the ability to do right to work checks remotely, whereby the individual would have the document in their possession rather than the employer have it, and you could do a check through a video link. Those have been extended at various points through the pandemic, and most recently, just last week, they announced that they were going to be extended until the 5th of April 2022. And in the latest extension, which has said these COVID sort of remote checks can still be carried out, they have indicated that the Home Office is exploring new secure remote checks for the future, because employers like the fact that they can do these checks remotely without having to sort of meet in person. And I guess given the new ways of working remotely, which has become much more common, I think that's good news for employers that they're looking at ways to continue even after that 5th of April date. But for now, we've got the ability to continue to do those remote checks. And they have said you don't need to go back and redo those checks when people get back to the office or meet face to face. If you did them in accordance with the COVID measures, then that's acceptable. So briefly, in my last slide, I've just got some practical tips to take away. So the position from the 1st of January might well be very different than it is just now. If you discover that you've got an EEA national who hasn't applied in time to the scheme, so bear in mind these measures are transitional measures, they're exceptional, it's not the norm, and it's special concessions in place right now. So it may be that from the 1st of January the position will be different, but I would say check and watch this space, because the Home Office sometimes does introduce further sort of extensions to those exceptional measures. So we will see whether or not the position will change from the 1st of January. Remember also that these interim measures are an exception rather than the rule, and for people with different types of visa application, if they don't apply in time, normally they cannot work for you in the meantime, and normally that would lead to a dismissal process. Be careful if you are signposting people to the EU settlement scheme to telling them to make their application within 28 days, not to stray into giving immigration advice, because it is regulated. And then finally, the good news is that it looks like right to work checks will become more straightforward and simpler to do in the future. And we will see what the Home Office announces in terms of those changes. So I think we're going to move on just to some questions and answers. And I don't know if you want to.
Yeah, we have had a couple in, but if you do have any questions, do pop them in the Q&A box and we'll try to get to them. So one of the questions we've had is, should we have asked employees that we know don't have a UK passport if they have applied for settled status or status under the settlement scheme?
So the Home Office's position is that the employer only had to do right to work checks, and the right to work checks that were applicable at the time when the employment commenced. So if at that point in time someone presented you with a European passport, say if they were starting work in like March this year and a European passport was acceptable at that point in time, the Home Office's guidance says you don't need to do additional checks on those people and you don't need to make inquiries beyond that. So they did say you don't need to ask about applications to the EU settlement scheme, etc. That's basically going above and beyond what they expect of employers. If you have chosen to do that and to get additional information about whether they have or haven't applied, I would say you then need to potentially take action based on that, because if you find out that somebody then hasn't applied in time, for example, you've then got knowledge that they haven't, and in that case, I guess you've got the interim process set out by the Home Office to follow, so you would then tell them to go off and apply and follow the checks as we've talked about.
Okay, someone else has asked, are there two separate online checking services, the employer checking service and a separate one dedicated to confirming the EU settlement scheme? So yes, there are two different services. One is the employer checking service, as you mentioned, and that's used to confirm usually that an individual has an application that's outstanding with the Home Office. So it's a slightly different service, and you will either get a positive or a negative verification notice, which is a separate document for right to work purposes. There's also now the online right to work service, which is totally separate, and that's used for those with digitised visas in the UK. So that does include those with status under the EU settlement scheme, but it also includes those, for example, with graduate route visas, those with certain biometric residence permits. So it can cover a whole range of different people, not just those with the EU settlement scheme.
Okay, and I think there's one in here that says, if there's no need for retrospective checks for current employees, how would I know if they applied to the EU settlement scheme or not? And I suppose on that, the Home Office's position is that it's not the employer's job to police whether they've applied or not. It might be that you do have individuals in your organisation who just didn't ever apply to the EU settlement scheme, or might have applied late. And it only becomes the employer's sort of job to do something about that if it comes to your knowledge, but it's not your job as the employer to go and root those people out, as it were. So they say, provided you did right to work checks that were in place and were applicable at the time when the person started employment, then you've got your statutory excuse. They do, as I said earlier, provide for scenarios where the employer might elect to do additional checks that go above and beyond what the Home Office expect, but they do say, we don't expect you to go out and double check or make inquiries into European nationals and whether they've applied in time or not. Are there any other questions? I think we've got maybe 1 minute left for one final one.
Yeah, so I think there's one other that asks, do we need to check original passports or right to work documents at final interview stage ahead of checking again on their first day of employment?
So it's up to the employer when exactly in the process they do right to work checks, as long as it's prior to the employment commencing. Some employers do it at a very early stage, others will do it at a later stage. They do recommend that you do it at the same stage for everybody, that you've got a consistent approach and you don't do it at different stages for different nationalities, for example, that you decide what your policy is and then you stick to it for everybody. I would say it probably makes sense to do it at a relatively late stage of a recruitment process so that you're not having to get unnecessary information in. But yeah, it has to be done before the employment commences, and you've got to keep the records of it throughout the employment and for 2 years afterwards. And I guess that's the critical piece. I think we'll just draw the session to a close there. If we've not been able to deal with your question, we'll hopefully come back to you on that separately. But thanks very much for joining, everybody.
Thanks.